Welcome to The Explainer. Okay, if you're gearing up for your paralegal licensing exam, you know the duty to your client is huge. But what happens when that duty crashes right into your obligations to other people, like opposing counsel or even the law society itself? Well, that's exactly what we're going to break down today, your professional duties to others.
So here's our game plan. First, we're going to get the big picture view. Then we'll get you trained up on spotting the red flags that the LSO loves to hide in their exam questions. After that, we are going to nail down the core rules you absolutely have to know cold, peek at the tricky exceptions, learn how to dodge the common traps, and finally, look at what happens when these rules get broken. Let's dive right in. All right, let's get into the big picture. The core of this whole topic is a constant balancing act. It's like you're walking a tightrope. On one side, you have this duty to be a fierce advocate for your client, but on the other side, you've got all these duties to everyone else. The exam is totally designed to see if you know how to walk that line without falling. And this slide really says it all. Your duty to your client, super important, absolutely. But it doesn't just erase everything else. Think of it more like a constant negotiation between what your client wants and what your professional obligations demand of you, to the law society, to your colleagues, and to the justice system as a whole.
So why does this matter so much on a test where every second counts? Because the LSO loves to test you on this exact conflict. They're going to give you a scenario where your client is pushing you to do something that just feels, well, a little bit off. Maybe it's being a jerk to opposing counsel, or maybe it's trying to hide some misconduct. Your job is to spot that conflict and know which duty wins out.
Okay, so let's move on to spotting the exam triggers. These are the kinds of fact patterns that should be like a giant flashing neon sign in your head screaming at you that you're being tested on your duty to others.
Oh, this is a classic. A total classic exam trigger. Opposing counsel messes up. They missed a deadline by a day. Maybe they filed the wrong form. So can you use that to score a cheap win? The rules say nope. If the mistake isn't about the actual substance, the merits of the case, taking advantage of it is called sharp practice, and your duty of courtesy under Rule 7 says that's a no-go. On the exam, the right answer here is pretty much always no.
And here's another super common scenario. You find out a fellow licensee has just, poof, disappeared. They've abandoned their practice, and their clients are left totally stranded. Your duty here? It's not fuzzy at all. Rule 9 makes it mandatory. You have to report this kind of serious misconduct to the law society. Just looking the other way is not an option.
Now this trigger tests a totally different duty. Your duty to report yourself. Bylaw 8 is really strict about this. If you get charged with certain offenses, like any indictable offense, you have to tell the law society. And it doesn't matter one bit if it's completely unrelated to your paralegal work. The duty to self-report is absolute, period.
All right, now for the stuff you absolutely, positively have to have memorized. We can really break down this whole duty to others thing into 3 main pillars.
Pillar number 1 is Rule 7. This is all about how you deal with other licensees, and that means everyone. Opposing counsel, co-counsel, even people who don't have a representative. The guiding principles here are always professionalism, courtesy, and good faith.
You need to know this list inside and out. I mean, burn it into your brain. An exam question will describe one of these behaviors and ask if it's professional misconduct. If it's on this list, the answer is a hard yes. I'd pay extra attention to 2 of these: sharp practice, which we just talked about, and communicating directly with someone you know has a lawyer or paralegal. Those are huge red flags and total exam favorites.
Okay, pillar number 2, your duty to the regulator itself, the Law Society of Ontario. You have to remember, when you become a licensee, you're basically agreeing to play by their rules, and that comes with some very specific, very serious obligations. Just look at the scope of these duties. They aren't passive things. You have an active duty to respond to the LSO, to report bad behavior you see in others, and even to report yourself. And that first point is so important. If you fail to respond to a communication from the LSO, that is professional misconduct all on its own, even if the original complaint against you is total nonsense.
This slide right here is pure exam gold. It lays out a very specific procedure, and you know how the exam loves to test procedures. So let's say your client got ripped off by a dishonest licensee, and they just want to make a quiet settlement to make it go away. You can't just nod and agree. You have to follow these 3 steps, precisely and in this exact order. Our third and final pillar is the broadest one of all: your duty to the administration of justice. This goes way beyond any single client or any single case. As a paralegal, you're an officer of the court, And that's a title that comes with a heavy dose of responsibility.
This basically means you have a fundamental role in making sure the public keeps their confidence in our legal system. And a key point here for the exam is that last bullet point, helping to prevent the unauthorized practice of law. If you find out that someone is pretending to be a paralegal or lawyer when they aren't licensed, you have to a duty to report it.
Okay, so we've covered the main rules. But on the exam, just knowing the rules is only half the battle. You want to know what gets you the points? Knowing the exceptions. That's where they hide all the trickiest questions.
And this is the single most important exception you need to know. Your duty to report serious misconduct is mandatory, right? But it does not, I repeat, does not override your duty of client confidentiality. The exam will 100% give you a scenario where these two duties are at war, and you have to remember the hierarchy. Confidentiality wins, unless there is a very, very specific exception, like preventing future harm, that lets you disclose.
Now let's talk about the common exam traps. These are the little distinctions that can so easily trip you up on a multiple choice question if you're not careful. Mastering these is key.
You have to know the difference between these two. Think of it this way. Professional misconduct is when you mess up while you're on the job acting as a paralegal. Conduct unbecoming, on the other hand, is when you do something in your personal life that is so bad it reflects poorly on the entire profession. Think something like committing tax fraud. It might happen on your own time, but it still makes the public lose trust in legal professionals.
This is another one of those subtle but absolutely critical distinctions. When you're reporting another licensee for some kind of criminal activity, the duty to report only kicks in if that activity is related to their legal practice. But when you're self-reporting a criminal charge under Bylaw 8, that connection doesn't matter. If it's a reportable offense, you have to report it, end of story. So let's bring this all home by looking at the consequences. What actually happens when these rules are broken? Honestly, knowing the stakes makes all these abstract duties feel a lot more real. This isn't just theory, okay? These breaches have direct and really serious consequences. Just take a look at that first row. Failing to respond to the LSO, that's like low-hanging fruit for the regulator. It's an easy misconduct finding for them to make. So your number one rule should be always, always, always respond.
And that brings us right back to the central question you should keep in your mind as you study this stuff. When what your client wants clashes directly with your professional duties, which one wins? Your duty to your client is primary, yes, but it is not absolute. Knowing exactly when your duties to the profession and to the public have to come first, well, that's the key to this entire topic and to acing your exam.